What makes a contract legally binding? Is it the signature at the bottom of the page, or is it the handshake that seals the deal? Well, it's a bit more complex than that. A contract, in its essence, is a legally binding agreement between two or more parties. It creates obligations that are enforceable by law. But for a contract to be formed, certain elements must be present. Firstly, there must be an offer. This is a promise to do or refrain from doing something. Secondly, there must be acceptance. This is an unconditional agreement to the terms of the offer. Thirdly, there must be consideration. This is something of value exchanged for the promise, often money, goods, or services. Additionally, there must be an intention to create legal relations. This means the parties must intend for the agreement to be legally binding. There also needs to be capacity. The parties must have the legal ability to enter into a contract. And lastly, the contract's purpose and terms must be legal. Now, contracts can take various forms. They can be express, where terms are explicitly stated. They can be implied where the contract is inferred from the parties' conduct or circumstances. They can be bilateral, where both parties exchange promises, or they can be unilateral, where one party promises to do something in return for the other party's performance. There are also void contracts, which are invalid from the outset, and voidable contracts, where one party has the option to enforce or void the contract. Then, there are executed contracts, where all terms have been performed, and executory contracts, where some or all terms remain to be performed. But what happens when a contract is terminated? This can occur through performance, where parties fulfill their contractual obligations, or through agreement, where parties mutually agree to terminate the contract. Termination can also occur through frustration, where circumstances arise that make performance impossible, or through a breach, where one party fails to fulfill its obligations. Additionally, contracts can be terminated by operation of law due to illegality, bankruptcy, or death. When a contract is breached, certain remedies can be sought. These include damages or monetary compensation and specific performance, where a court orders the breaching party to fulfill their contractual obligations. There can also be rescission, where the contract is cancelled, and injunctions, where a court orders a party to refrain from certain actions. And let's not forget, in the world of business, contracts play a pivotal role. They govern relationships between businesses, suppliers, employees, and customers. So, understanding the law of contracts is essential for anyone who wishes to protect their rights and obligations when entering into agreements. It provides a framework for resolving disputes and ensuring fair dealings between parties. In a nutshell, a contract is not just a piece of paper or a handshake. It's a complex legal instrument that governs our agreements and obligations, ensuring that everyone plays by the rules.